Good afternoon, and thank you for joining us for our webinar, Common Wage and Hour Issues in Benefits. I'm Julia Goebel, Chief Marketing Officer at Benefit Express, and I will be your moderator today. This webinar answers questions surrounding the Fair Labor Standards Act, FLSA, what employers can expect, and overall FLSA best practices in the workplace. Making a mistake on employee payroll obviously impacts the employee, but it can also cost you, the employer, in lawsuit damages. In fact, employers pay millions of dollars each year to settle wage hour lawsuits. The kicker? Much of that liability could have been avoided had the employer reviewed and changed its pay policies. With that, this webinar will explore the Fair Labor Standards Act, common wage and hours mistakes, how to avoid pitfalls, whether employers should offer benefits to independent contractors, determining if part-time employees should be offered benefits, and the timeline for terminating benefits if an employee goes part-time, and much more. Don't let these preventable mistakes take your business down. Stay with us for the next 45 minutes to learn how your organization can remain compliant and avoid the most common pitfalls. A few housekeeping items before we get started. If you missed something, don't worry. We'll be emailing you the recording and the slides after the webinar concludes. I'll be keeping the webinar muted to avoid any background noise. We'll pause throughout for questions. Simply type your question into the box below and I'll read it aloud for you at the end of each section. If we don't get to your question today, we will be sure to email you a response. ERISA Attorney Larry Grudzien is our presenter today. With more than 35 years' experience in employee benefit law, Larry has a wealth of experience in dealing with qualified plans, health and welfare, fringe benefits, and executive compensation areas. Thank you for joining us today, Larry. We are delighted to have you. And with that, I will hand it over. Larry, please take it away.
Thank you very much. I think that the basic issue in dealing with this area, and you're going to see this during the presentation, is that we're going to review the wage and hour what's required, but I think what's important and where the issues come up, and this has become I think extremely important, and the DOL and IRS realize this. What many employers are doing is they're either hiring part-time people or they're making some of their employees independent contractors. Just recently, I think in 2020, the state of California passed a state law requiring employers to start treating independent contractors as employees. So, I mean, this is a hot issue. So we're going to be talking, and one of the major issues is that both state and federal governments are looking at misclassification crackdown, employee versus contract, independent contractors, exempt versus non-exempt. And a new area that you may not be familiar with is joint employment, where you have an individual that may work for a number of different employers, and in some situations it's called a joint employment situation. And in that, one of the employers that employs that person may have to collect all the hours and treat that person as full-time. And I'll be talking about that. There's been some recent developments in that area. So I'll also be talking about deductions from salary, which you can and cannot deduct from salary. And then also, as I indicated, states are getting involved in this. So depending on where you're operating, you have to worry not only about the federal rules, but the state rules. Because in many situations, the states are much more generous than the federal government, especially minimum wage. And then we're going to see, okay, what are the liability for violations in this area? And then I'm going to wrap it up in talking about the various benefit issues that are impacted when you have a question about misclassification. So we're going to be talking about that, and I'm going to pinpoint in the benefit issues. So first of all, let's look at the wage and hour overview. So the federal Fair Labor Standards Act was enacted in 1938, and the major areas that it impacts is minimum wage, overtime pay, employment of minors, record-keeping requirements, and that's enforced by the U.S. Department of Labor. And I think what they're really interested in is making sure that employees are not employed off the clock. and they get the all the wages and all the benefits they're entitled to. So again, now those are the federal rules, and we'll be talking about the state rules in a few minutes. So who has to comply with this? Well, it's any private employer with 500,000 or more in revenue, or 2 or more employees engaged in interstate commerce. And now almost everybody is. I'm a sole proprietor and I'm in interstate commerce. I have clients all over the country. Also hospitals and other healthcare institutions, private sector employers, schools, most not-for-profits, and trade associations all are subject to these rules. So almost everybody is subject to these rules and they have to comply with them. Now, again, as I indicated, and I can't, of course, cover all state laws, but here, what this slide indicates is almost every state has its own wage and hour rule, which may or may not prescribe a different hourly wage that is prescribed by the federal law, and which may or may not follow the exemptions afforded under the federal law. State laws typically are more generous to employees in terms of minimum wage, the scope of exceptions, and the definitions of operative terms such as overtime. Many states require overtime pay in situations that are much more favorable to employees than under the federal law. In seeking to comply with the law, the employer should always consult with both federal and state laws concerning wage and hours. And I think what's important too, you have to look at, because many states are getting involved in this, and especially they're mandating paid leave, sick time. All this is, again, if you're doing business there, you have to look at all the local rules to see exactly how it impacts how you pay an individual. Now, because of the changing way people pay individuals, both the DOL and IRS are looking at ways of dealing with misclassification of employees. So the DOL crackdown on employers who mistakenly misclassify workers as independent contractors and are employees under the law. There's several big cases. If you look at this, Microsoft got dinged about 10 or 15 years ago, where they had a number of people working for them as independent contractors, and they sued and they won because they said that we're treated as employees or controlled as employees, we should be employees. So what is the effect of misclassification? Again, as an independent contractor, they have no employment rights, that they have no right to overtime, no right to benefits, minimum wage and overtime pay, nope. Workers' comp, nope. Family and medical leave. They can be dismissed for any reason at any time. And they've, as an independent contractor, they have absolutely no protections at all. And again, over the last 10 or 15 years, many companies are turning to independent contractors, especially in certain parts of the year when there's an increased demand. So they hire people, and and one thing I've seen, and what I advise people, if you're going to hire somebody as an independent contractor, in most situations, what I advise my clients to do, if you're going to do, and they classify these as temporary employees. If a temporary employee works for you for a period of longer than 6 months, they're not temporary anymore. And the longer that person is working for you as an independent contractor, more and more they're going to be treated as an employee. And I've seen situations when I talk to employers, oh, we've had these temporary employees working for us for a couple of years. And that's extremely dangerous because then they're really not temporary employees. And as that worker works for you longer and longer period of time, what I've seen in that situation, the employer controls more and more when and how they work. So the test for independent contractors, there's both federal and state rules. The DOL has economic reality test. Is a worker truly in business for himself or herself, or is he or she economically dependent on the employer for work? And again, that's a facts and circumstance test. And then the DOL has a 20-point test: behavior control, financial control, relationship between the parties. And then state rules, you have to check the state rules. There's worker comp, unemployment insurance, and state wage and hour rules that determine whether that person's your employer or independent contractor. Now, in this area, what's important, I think, what the emphasis is right to control. Is there compliance with instructions? Does that person need training to do, and does the employer actually conduct training? Are there tools involved that are supplied by either by the employee or by the employer? Is there a business car? Does that individual that you're hiring, do they hire their own employees? Are they hired by the project or by the hour? And I think if it's hired by the project, I think you have a stronger case that person's an independent contractor. Does that employee set their own hours? Or as you, an employer, tell the employee when and how to show up? Is that employee not terminable at will? I mean, you have a contract with that person to finish the job. If that person can be terminated at will, I think it's a better chance that a person is an employee. Who has the risk of profit or loss on the project? How is that person paid? Is they paid per week or at the end of the project? Reports, minimum or long-term basis, not daily or weekly. I mean, who does that report to, and whether that person that is reporting to, do they have control over that individual? And of course, no company benefits, vacation time, sick time, health insurance. And one of the factors I think in this area that the IRS especially looks at, whether that person is an employee, and I've gotten increased questions over the past couple of years, that more and more employers, especially if they have an independent contractor that they like, what they'll do is say, well, we're going to include them in our benefit programs. And I warn people that, in fact, that's one of the aspects of the test that the IRS looks at to see if that person is really a independent contractor or an employee. And also, there's all kinds of ramifications under the DOL rules. The fact that basically what the employer has done by including independent contractors, that they've created a multiple employer welfare arrangement, a MIWA. So there's all kinds of issues in regard to that. In recent years, the states have established ABC tests for determining common law and versus independent contractors. These tests affect state taxes like income tax and state unemployment. And again, this is something that the states want to collect. At present, 26 states, including California, and have some variation of these tests. These tests under state law generally have three aspects to them. The worker is an independent contractor if these tests are met. The worker must clearly be free from being required to take direction for work performance as shown by both the terms of the employment contract and actual working relationship. The work must be outside the employer's usual business activities. If the business is a trucking company, and a trucker would be inside the usual business activities, but a plumber would be outside the usual business of a trucking company. So the closer that individual that you're hiring is closer to your business, the likelihood under state law that person would be considered to be an employee. And workers must be customarily engaged as an independent business or a business similar to the work performed for the hiring company. And some states, like California, use all three tests, while other states only use two. And again, you have to, and again, not just look at the IRS and DOL rules, but you also have to look at the state rules to see exactly what your state actually requires the fact that that person be an employee. So what are the consequences of misclassification? There could be overtime liability, back pay, liquidated damages, double damages, criminal penalties, fines up to $10,000, willful penalties, $1,000 violation and imprisonment, payroll taxes, withholding penalties and interest, IRS and DOL audits. I've been involved with some of my clients, and what What triggers an IRS DOL audit is the fact that you as an employer are filing a lot of 1099 miscellaneous. That will trigger an audit saying, they have 30 employees, but they have 20 or 30, they're issuing 20 or 30 1099, because if you pay somebody more than, I think it's $600, you have to give them a 1099 miscellaneous. And that's going to, again, be looked at. So it could trigger an IRS or DOL audits, liability for medical expenses for work-related injuries, attorney's fees, and costs and other consequences. So again, this is a big deal, and this is an area both the IRS, DOL, and the states are looking at, because they're all not sharing in the taxes not collected when that person is deemed to be an independent contractor. Now, another big area is the exempt versus non-exempt. And a situation where, and word comes in, if it's an exempt employee, that person is not, that employer is not required to provide overtime for that individual. Now, just recently, and this has been a hotbed of activity from the DOL, because the Obama administration published rules that were very generous in 2014, and then they were withdrawn when Trump came in. And then the Department of Labor revised the regulations with the effective date as of January 1st, 2020. So this is brand new. So the Wage and Hour Department will continue to enforce their 2004 rules through December 31st, 2019, including $455 per week standard salary level and $100,000 annual compensation level for highly compensated. And I gave you a link to the final rules, which are effective as of January 1st, 2020. So here for white collar, this is called the white collar exemption. Generally, the salary level at least $684 per week. Primary duty, it does not, primary duty, in other words, to be white collar, it must be at least 50% of their time. And primary is principal, main, major, most important. In some situations, that person could have other duties, but the primary the primary duty they have is the white collar. So you could have a supervisor, for example, who's blue collar, but if they supervise people, that's their primary duty. So therefore, they would be an exempt employee. So let's look at the executive exemption. The primary duty is management of a recognized separate department or subdivision. Customary and hourly regularly work supervises 2 or more full-time employees or equivalent, has authority to hire and fire employees or recommends to the hire and firing advancement, promotion, and is given a particular weight. So what we're talking about here is especially in a situation where you have either a restaurant, a hotel, and only certain individuals would be exempt because they have those duties as indicated, because they're supervising individuals working at the hotel or restaurant. So they would be considered to be exempt employees. So it's basically not what you're paid. You could be paid a salary and still not be an exempt employee. That's what I'm trying to get at.
So Larry, we have a question from our listeners, and this comes from Ashley D. Ashley asks, will these slides be available after the webinar? And yes, we will provide a copy of the slides and a link to the webinar recording, which is slides and audio. So thank you for asking, and everyone, if you have any questions you'd like us to read aloud and answer by Larry, I would be happy to share those in the upcoming minutes.
We can stop at any time. So if there's something you want a clarification on, another example, or just have a general question of how this applies, please stop me. I could go on forever. So now let's look at the administrative exemption. These are individuals generally that work at an office. So again, the primary duty is office, non-manual, directly related to the management of general business operations of an employer or employer's customers and clients. And these are people that work, you could have a large employer that has an office staff, somebody in accounting, somebody in HR, these individuals can be exempt employees. So the primary duty includes exercise of discretion and independent judgment with respect to matters of significance. Examples, typically claims adjusting, financial services, HR, auditing, tax, marketing, and quality control employees. Another exemption is learned professional exemption. These are a performance of work requiring an advanced type of knowledge, accountants, attorneys. The employer must be compensated on a salary or fee basis, primary intellectual and character, consistent exercise of discretion and judgment in science or learning, prolonged course of socialized intellectual instruction. Again, accountants, attorneys, anything that requires a BA or BS. Again, the examples that I've seen here is accounting, law, education, medicine, engineering, and architecture. These individuals are paid on a salary basis, and they are considered to be exempt employees. Another classification exemption is a creative professional. This is the performance and work required in invention, imagination, originality, and talent recognized field of artistic or creative endeavor. This is an employee must be compensated on a salary or fee basis. This includes music, writing, acting, graphic arts. So in case-by-case basis, depending on, I think there's a blurred line between who is creative and who is the support staff, who should be considered to be not exempt. So again, if someone is creative, that person is considered exempt and would not have overtime. Computer professional exemption. These employees must be paid on a salary or fee basis, not less than $684 a week, or compensated on an hourly rate not less than $27.63. Again, they would be considered to be exempt. The employee's primary application and systems analysis techniques and procedures, design computer programs, the creation and modification of computer programs, and a combination of all the duties. So again, your IT person would be considered to be an exempt employee, and the employer would not have to, because you never know, I think that this is realistic, you never know when the system needs tweaking or maintenance or whatever, and so these employees would be treated as being exempt. Another exemption is outside sales. Making sales or obtaining the primary duties, making sales or obtaining orders for services or for the use of service facilities, and employees customer and regularly engages in work away from the office, no salary requirement or particular salary level, and regulations exclude from the exemption inside sales. So these are people that are generally outside the office and a sales capacity. These people would be considered to be exempt. Now, there's another exception called the highly compensated employees. These are people that are paid $107,000, $432 or more. They are exempt if they meet any one of the prior exemptions: executive, administrative, or professional duties. They must have office or non-manual labor, significantly higher than $65,000 proposed. So again, the $107,432 would be considered to be salary, commissions, and non-discretionary bonuses. So if they're that and they meet one of the other definitions, they would be considered to be exempt. Now with this next slide, blue collar, the exemptions provided under the Fair Labor Act apply only to white collar, and exemptions do not apply to manual laborers or other blue-collar workers who perform work involving repetitive operations with their hands, physical skill, and energy. But depending on the size of the employer, and if another individual is in a supervisory role and their primary function is that's going to be a facts and circumstance basis to determine whether that person is either white collar or blue collar. So again, you have to look at the cases to see under what situations a blue-collar worker because that person is supervising individuals would be considered to be a white-collar. Other situations, the exemptions do not apply to police officers, detectives, deputy sheriffs, state troopers, highway patrol officers, investigators, inspectors, correctional officers, parole and probation officers, park rangers, firefighters, paramedics. So anyone who's dealing with that would not be considered to be exempt. So they would have to be paid overtime, which is, again, a big issue for, for state and local governments. But again, those individuals would not be considered exempt, and they would have to be paid overtime. Now let's look at a particular situation. A sushi chef at a restaurant, supervised by head #1 chef, paid on a salary basis, not required to have a degree in culinary arts, but is continually instructed at the restaurant in a classroom setting, required to have 5 or 10 years of experience, oversees the work of less experienced sushi chefs, does not hire, fire, promote, or discipline lower level chefs. Is that person exempt under the executive exemption, exempt under professional exemption, exempt under administrative exemption, or is he not exempt? Not exempt. Under the executive exemption, no evidence that the mid-level chef made suggestions or recommendations as to hire, firing, promotion, or of lower level chefs. Not exempt under the not unlearned professional exemption that did not require any academic degree. So that person, the effect of that would have to be paid overtime. So again, this is extremely difficult. Some of this is based on facts and circumstances. So an employer has to be very, very careful and how they categorize each of their employees and looking at and as you can see from this, you can't just pay somebody a salary and say you're exempt. And what this is trying to show is the fact that you have to look at their duties involved. Just because you pay someone a salary, it's not determinable. What their duties are is determinable with that, whether you have to pay that person overtime. So let's look at the cost of misrepresentation. Jim is an assistant manager at a wellness pharmacy. He has no supervisory authority and does not manage others. He is not exempt. Jim has been treated as an exempt employee. His pay over the last 3 years have been at a rate of $15 per hour. Jim now claims he has worked 45 hours per week for the last 3 years. He has not been paid overtime. So number of hours, 40 hours times 1.5 regular rate, 2 years or 3 years, willful, now for 2 times liquidated damages, times the employees, attorney's fees, cost of litigation. Individual action, 150 weeks times 5 hours a week, 750 overtime pay, 750 hours overtime pay, $22 an hour. Liquidated damages, it gets twice as much. Instead of $16,875, it gets $33,000. Or it could be a collective action. 100 current or former assistant managers join in a collective action. 100 times $16,875 equals $1,687. Liquidated damages is $3 million. So this mistake can be very pricey. Also involved, under the Fair Labor Standards Act, prevailing plaintiffs are entitled to award of attorney's fees. And that jumps it up even to a third or a half. So again, in addition to that, you have to defend this case, so the employer has to look at their own defense. So again, this mistake can be rather costly in trying to save money. So you have to be very careful in categorizing your employees and making sure that you're categorizing this properly, because as you can see from this, the mistake can be extremely costly. Julia, do we have any questions?
At this time, we're happy to accept any questions you may have. Simply just chat them into the questions box and I will read them aloud. I would like to take this opportunity to launch a poll for everyone watching. This poll is related to health and welfare programs. What is your biggest pain point with administering health and welfare programs? You will see this on the screen, and there are 5 choices. 1, keeping up with compliance requirements. 2, driving employee participation. 3, providing employee education and communication. 4, managing up, including reporting objectives and results. Or 5, none of the above. And we see that the responses are coming in. More than 45% of you have voted. And we'll leave the poll open just for a few more seconds so that everyone has an opportunity to comment. Once again, if you have an opportunity to answer this quick poll on the screen, what is the biggest pain point you see in the above choices? Or perhaps one doesn't apply, in which case we'd be interested to know what maybe your other pain point could be. And I'll be closing the panel in 5, 4, 3, 2, and 1. Thank you to everyone who voted. We saw that majority of you say keeping up with compliance requirements is a major pain point, 38%, followed by 38% also saying providing employee education and communication. So thanks for sharing your feedback with us. Let's roll on.
Thank you. The next area is a new area. Guidance on this came out a few weeks ago. And the first question you may want to ask yourself, what is a joint employment situation? What does that come in? Well, this is important. I think come to mind is the fact that PEOs have that's the prime example of a joint employment situation, a situation where the PEO decides to take on certain functions and the employer is left with other functions. And here, I think there's all kinds of issues involved in, okay, is this person full-time, part-time? Who does the reporting? Who does various duties? The other situation that we'll look at temporary agencies, and we also look at franchisees in the parent company. Under what situations would there be a joint employment situation with that? So let's look at that. So when does it exist? When do you have to worry about that? And I think most employers don't have a worry, but it's becoming more and more of an issue. There are 2 potential scenarios where an employer may have one or more joint employers. The employee has an employer who suffers, permits, or otherwise employs that person to work, but another individual or entity simultaneously benefits from that work. Secondly, one employer employs an employee for one set of hours in a work week, and another set employer employs that same employee for the separate set of hours in the same work week, and it could be related or unrelated companies. And this is becoming more common, especially ACA, because remember, if you employ that individual and they work at least 30 hours, you have to provide them health benefits. And some employers have said, aha, I'll share employees with somebody down the street. They work 15 and 15, and therefore that person's not considered to be a full-time employee, and I'll just switch them. So many days they work for me, and so many days they work for that other person. I've seen that occasionally. So what are the factors involved and used to determine if a joint employment situation exists? There are 6 factors to identify. Whether the joint employment employers jointly control on how the worker did his job. Whether the joint employer shares power over hiring and firing decisions. How long the joint employers have been working with each other. Whether one joint employer exercised control over the other. And whether the work was done at the location controlled by one or more of the joint employers. and whether that the joint employer shared responsibility regarding tasks typically handled by the employer, or such as payroll. So you have to look at, I think what's primary in this is the fact that the two entities are sharing responsibility for this employee. Now, what are the consequences? What is the effect of if a joint employment situation is found? So if the employers are acting independently of each other and are disassociated with respect to the employment of the employee, each employer may disregard all work performed by the employee for the other employer in determining liability under the Fair Labor Standards Act. However, if employers are significantly associated with respect to the employment of the employee, and again, we're looking at a PEO, temporary agency, or again, franchise situation, possibly, they are joint employers and must aggregate the hours worked for each other for purpose of determining if they are in compliance. Employers will generally be significantly associated if there is an arrangement between the two of them to share the employee services, and the employer is acting directly or indirectly in the interest of the other employer in relation to the employee, or they share control of the employee directly or indirectly by reason of the fact that one employer controls or is controlled or under the control of the other employer. So this is very specialized, but if you enter an arrangement with another employer, be very careful and count all the hours in this situation. Let's move on. So what deductions can be taken from salary? In regard to a exempt salary deductions, generally exempt employees must be paid to their full salary for all weeks worked in which they perform any work, regardless of the quality or quantity of work. And again, be very careful in a sense that I've seen some employers make hourly employees salaried, and beware of fake salary. And they're really hourly, but they're given a salary. Can lose the exemption for all employees on the same job and classification for the affected department. So please be very careful in categorizing. Now, in regard to salary, you can deduct absent from work for one or more full days for personal reasons, absence due to sickness or a disability for a full day if the deductions are made on a bona fide plan, policy, or practice of providing replacement pay for these absences. No deductions or offsets for jury duty, witness fees, or military fee. Deductions for any type of may be imposed for good faith for violating safety rules, unpaid disciplinary suspension for one or more full days, a proportionate rate of full salary for time actually worked in the first or last weeks of employment, or any unpaid leave pursuant to family and medical leave. Now, when you're doing this, what you have to do, if you're going to, in certain situations, deduct pay, what you have to do is have a written policy explaining to the employees when their pay will be deducted. And that written policy must be provided to all employees. It can contain a complaint procedure, and then employer, if there is a mistake, responds and corrects any errors. And full reimbursement can be made in that situation, but you've got to be real careful in what situations you're going to deduct pay from an exempt employee's pay. Now, some employers have asked me about comp pay. That person, for private employers, all wages must be paid for pay period at an issue, and makeup time cannot be extended. The situation is for public employees, complementary time can be accrued up to specific limits and must be reasonably available for use and must be paid out of on termination. So again, you can't do makeup time, and you can't give somebody extra hours in that situation. Now, the other issue, big issue, is intern or employee. Here, college students agree to provide unpaid services to a company. Students perform low-level tasks such as answering phones, making deliveries, picking up paychecks for other employees. And the company provides training in how to perform these services, but are not overall business. Students receive academic credit, no expectation of receiving a job at the conclusion of the service. On the questions asked, are these individuals interns or employees? So here, unpaid interns, they receive academic credit. They agreed that they won't be paid for the services. The employees that perform the work that other employees would have to do, and sometimes the employee doesn't know. Here, a real life case, Fox Searchlight, employees work not primarily benefit interns. Company did not provide training on occupational operational aspects of the business, and other workers cannot waive federal coverage. On appeal, the court applied the primary beneficiary test. Here, courts use the primary beneficiary test to determine whether the intern is a student or in fact an employee. In short, the tests allow courts to examine the economic reality of the intern-employee relationship to determine which party is a primary beneficiary of the relationship. And I think in this situation, what courts look at, the courts looked at 7 factors in looking at this. The extent to which the intern and employee is clearly understood that there is no expectation of compensation. Any promise of compensation, expressed or implied, suggests that the intern is an employee, vice versa. The extent to which the intern provides training that would be similar to that which would be given to an educational environment, including the clinical and other hands-on training. The extent to which the intern is tied to the intern's formal education or receipt of academic credit. The extent to which the internship accommodates the intern's academic commitments. The extent to which the internship's duration is limited to the period in which the internship provides the intern with beneficial learning, and the extent to which the intern's work complements rather than displaces the work of paid employees while providing significant educational benefits to the intern, and the extent to which the intern and the employer understand that the internship is conducted without entitlement to pay at the conclusion of the internship. So the more the training there is, and more it's tied to the education of the employee, the more that person will be considered to be an intern and is not considered to be employed. So what are some of the state law issues? What you have to look at, especially state and local wage and our issues, minimum wage. Again, some areas have higher than federal. Overtime exemptions defined differently under the Fair Labor Standards Act. Some states have more generous meal and break time periods. Are meals and breaks required, paid or unpaid? And also wage payment laws. How often must the workers be paid? When must the final paycheck be made? And must be included in the itemized wage statement. Now, who is liable for these violations? Extremely important to look at. So, any person directly or indirectly in the interest of the employer in relation to the employee, any person who has a power to hire and fire, control over the schedule of the worker, maintenance of records, control over the method or rate of pay, control over business enterprise, and also there's possible criminal violations in this. So again, be very careful. So again, the DOL is cracking down on these violations. Private lawsuits are on the rise. And again, the state of California said basically more and more employers have to treat these independent contractors as being employees. As you can see, misclassifications and other violations are costly. And what you need to do is perform regular audits to ensure compliance. Employee versus independent contractors, exempt versus not exempt, pay deductions, interns, and proper record keeping are extremely important. So let's look at some related employment issues. First of all, let's look at worker comp issues. I get questions on worker comp issues all the time, and there's a lot of misunderstanding about what's required under workers' comp. In this situation, I think there's misunderstanding. If somebody goes on workers' comp, there may be one or two states, but generally I can make a general statement. Most state laws do not require a continuation of the general medical coverage on workers' comp. That means that unless that person on workers' comp qualifies for family medical leave, once that person has a reduction of hours, that person, if that employer is subject to COBRA, must be offered COBRA to continue general medical coverage for the wife, the kids, and their other ailments. They're going to be treated for their injury. That's true, but again, there's no protections generally, and no requirement that the insurance company has to continue to cover that person if there's a reduction of hours. So that's extremely important. I've many times I get a question once or twice a month. Well, we have somebody in workers' comp, and this was 2 months ago, and we haven't taken them off our medical plan. And I said, is that person eligible for family medical leave? No. I said, you have to look at your contract to see when you have to take off that person and offer COBRA. I think is extremely important. So again, 2 federal programs are extremely important here. We're looking at family medical leave and we're looking at COBRA. The only 2 situations that coverage can continue past termination, or past reduction of hours, I should say. So again, be very careful in working with workers' comp. Another issue is part-time employees. What benefits it offer? Remember, if that person is working less than 30 hours, there's no requirement to offer them any benefits at all. Some employers do. Do you offer them vacation or sick time? And you have to look at your state or local statutes to see under what situations that person is entitled to it. Most states don't have any rules on giving vacation to part-time people. If you cover them, there's also going to be COBRA issues. If you extend coverage to them, then once you extend coverage to them, then again, you have to offer them COBRA. And the cost involved. Are you going to have them pay the same amount as regular employees, or are they going to pay more? And how do you treat full-time employees who, and that should say, how do you treat full-time employees who go part-time, not full-time, part-time? Do you offer them, and generally in that situation, they become variable hour employees, and you have to look at either the look-back period or the monthly measurement and wait until that person becomes technically part-time to take them off. You have to look at turnover. You may want to offer part-time employees benefits because you have an immense turnover and you want to keep people. And the problem with pre-tax contributions is the fact that person may not have a regular schedule, so you may have an issue with pre-tax contributions. Independent contractors. Consequences of offering benefits. Well, as I indicated earlier, that's one of the factors the IRS looks at in determining whether that individual is actually an employee. What benefits are you offering them? If you offer them medical benefits, once you cover them, then you have to offer them COBRA. So even if that person is not an employee, if they were covered under your medical program, you have to offer them COBRA. And then once you start opening your plan up for non-employees, you have multiple employee welfare association issues. You become a MIWA. And depending on your state rules, there could be issues in regard to that, especially if you're self-funded, because many states prohibit self-funded MIWAs. So you got to be very careful in that regard. And at what cost are you going to offer these independent contractors coverage? Temporary employee issues. Start from an agency or direct hire. I mean, you have projects you want to be covering. Is that person going to be treated as an employer or independent contractor? Does it make a difference if you direct hire an agency? Well, yes, it does, because some agencies actually provide supervision and provide benefits. So it's less likely that person would be treated as an employee of yours. And again, the question you want, does the agency offer benefits? Now, you have to look at that situation, and you hire a temporary employee. The issue is that individual employee, is that going to be treated as a joint employment situation because you exercise control over that individual when they come in, what they do. So the longer that person is working for you, the more that you as an employer have control over that individual, and no longer are they the employee of the agency, they're employer of yours. So you have to look at the facts and circumstance. And as I indicated before, in these situations, 6 months is my cutoff point, and that person should no longer be employed. They're no longer what's called a temporary employee. Are there any questions? Julie, do you have any questions?
As we prepare to transition, I want to close with a poll and allow everyone to type in a question that they may have. Once again, we're happy to read your question live. I am launching a poll on your screen now. The question is, do you plan to evaluate your benefits administration partner? Describe your time frame. This year, prior to annual enrollment. This year, after annual enrollment. No plans, will evaluate in 2021 or beyond, or no plans to evaluate. And I'll give you just a few more seconds on the poll and then transition into any questions you would like to chat. I'm happy to read aloud your questions to Larry to help answer any open items you may have. And just a couple seconds left on the poll. We have feedback from most of you, just a few more coming in as we wrap up. Great, and we've received 70% of your feedback. Thank you so much for your inputs. This time, I'd like to offer one last opportunity to chat a question over to Larry. Happy to read it aloud for you.
When's the next seminar?
Our next seminar is coming up. We are scheduled for in February, and once again, we offer compliance webinars monthly. Our next webinar is focused on Medicare and employers, the interaction between Medicare benefits and employer-provided benefits. Sure to be an interesting topic. And we will be meeting again on February 27th. So thank you once again, everyone, for your participation. Truly appreciate it. We do plan to offer ACA content coming up. We have received a question. Thank you, Celeste, for asking. We have a number of ACA resources on our website, as well as ACA being a frequent topic, because we know that it is always an item that is studied closely in Washington and across the country. So I do expect that we will be adding ACA content webinars in addition to the ones that are already on our website at benefitexpress.info. And thank you so much for your participation once again. We look forward to seeing you and asking you to join us in upcoming ERISA compliance webinars. Thank you, Larry, to our distinguished speaker.
Take care.
Have a great day. Bye-bye.